All right. Good afternoon, everybody. This is a meeting of the House Criminal Law Subcommittee. It is Friday, February 28th. Apologies for the delay. It's that time of session in Annapolis. We have three bills on the docket today, and I want to move as quick as possible to let everyone back to their lives on Friday. So let's start with House Bill 877, which I hope is straightforward. This is from Delegate Ampry. This is, I believe, just a reporting and sunset extension on this bill.
Can you help me mute my phone, please?
Mayor, I move favorably.
Second.
All right. Is there any further discussion on House Bill 877?
There are amendments.
There are amendments.
Oh.
All right. If you want to tell us what the amendments do, perhaps they're changing the time. All right, let's take a look. They're changing. All right, do you want to keep scrolling? Interim findings. Claire, did this amendment come with any clear explanation of what it's attempting to do? I guess it's different than.
Jamie, I need you again. I'm sorry.
He said at the bill hearing that it was completely removing the sunset. The bill as it
What do you put again?
Okay, that's what it looks like. The bill was introduced, extended the group by 3 years, and gave them more time to do a report. And it looks like here they're moving an annual interim report and then removing the sunset. All right, does anyone object to this?
There was no opposition to this legislation at all, was there?
No.
I move favorable on the amendment.
Second.
All right. Any further discussion on the amendment? All right, all those in favor of this amendment, raise your hand or say aye.
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 Does anyone want to be recorded in the negative? Grammar? All right, Grammar's in the negative. All right, now we're on the bill. Do I have a motion?
Favorable.
Second.
All right. All in favor of the bill as amended, raise your hand or say aye.
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 Anyone opposed? All right, 2 opposed. Okay, now we're going to quickly do the state police bill. We voted this one last year already, but there is an amendment from the Senate, and Claire has attempted to further refine what that amendment was attempting to do. Claire, do you want to explain what you were able to learn from the Senate about what their amendment was trying to do?
Yes. So they were trying to, if we could scroll down, keep going. There, yeah. So they apparently, based on my conversation with JPR counsel, they did not want a sample of somebody to be placed in the database based on just a citizen charges based on a citizen application for statement of charges.
Right.
So that's why it says here, a determination is made by a judge or commissioner of the district court or a judge of the circuit court based on an application for a statement of charges filed by a police officer or a state's attorney that probable cause exists for a qualifying crime, and that's under current law, a qualifying crime. The individual has been arrested for a qualifying crime in accordance with an arrest warrant based on an application for statement of charges filed by a police officer or a state's attorney. So I just had to reword it because I noticed that the way that the Senate bill was worded was not correct. It didn't reflect this intention. And I did talk this over with JPR counsel, and they agreed on this new wording.
Okay. All right. Do I have a motion on this amendment?
Move favorable.
Could I ask a question?
Yes.
I just want, this is a tiny point, but it says application for statement of charges. Does that include, Claire, an indictment filed by a state's attorney if there's no application of statement of charges?
Well, if you look down at number 4, that
Oh,
is
great.
indictment.
Oh, I take it back.
Information is in 3 and indictment is in 4.
I'm so sorry. Then I move the amendment.
Second.
All right. All those in favor of the amendment, raise your hand or say aye.
Aye.
Does anyone want to be recorded against the amendment? All right. Do I have a motion on the bill as amended?
Move favorable, Mr. Chair.
Second.
Can I make a comment now that we've got a favorable motion?
Yep.
Just want to say that I think that the policy is much better and stronger with that amendment. I think it makes it a better bill because of all the discussions we're having about commissioners and filing for charges through that process. So I look forward to voting for the bill.
Okay. I believe we have a motion and a second.
Question.
Yes.
Yeah. So can someone walk me through the process one more time? I mean, we're putting in place criminal penalties for someone who refuses to give this, and then the same bill, it also alludes to the fact that we might have these samples kind of lingering around because they're not tested for some reason. Can we just walk through generally what the bill does one more time, please?
Yeah, Claire, do you want to take a stab at that?
Okay. So the bill is basically just kind of a cleanup bill, sponsored by the, requested by the, department. And, this has come in multiple years. And the main thing, it's my understanding that they're trying to do is that back when this law was originally put on the books years ago, maybe like 15 years ago, it said arraignment, that, this DNA sample goes in to the database at arraignment. Well, in Maryland, we don't have an arraignment phase. That's a term that's used in other states. And so this has caused a big problem because all these samples are just in limbo because, there is no arraignment. So that's the main thing, or one of the main things that the bill is trying to do, just get rid of that term arraignment. And I could pull up the fiscal note to just itemize everything else that the bill does. Yeah, so it
And I seem to recall part of the
clarifies.
issue too was the employees wanted clarity to make sure they weren't in violation of state law by failing to collect DNA at that stage. I think that was testimony from at least what part of what compelled the vote last year also.
Okay, I think I'm clear. Thank you.
Okay, is there any additional discussion on the bill as amended? Okay, all in favor of the bill as amended, raise your hand or say aye.
Aye.
All right, does anyone want to be recorded in opposition? No. Okay, great. All right, now on to the main event. We are rolling back to House Bill 21. If Chris, if we can put on the screen the latest language, which I believe is language that, as I understand it, the state's attorneys have spoken amongst themselves and with some of the advocates, and are proposing what you see on the screen here, which will be most of the things we discussed as consensus before: the perjury language, Embry's notification suggestion, and here you will see that they have removed the language allowing crimes of violence and sex assault to file commissioner warrants, and instead left the domestic violence language that was requested. So that is on the screen there. And we have, I believe, subsequently received data from Patrick Gilbert, at least as to how this process breaks out by type of case in his county. And so I want to start here. I have a lot of questions about implementation feasibility of the proposal here that I want to get into. But first, I just want to check the temperature on where members are on the type of proposal you see here. Again, this would allow the commissioner warrant process to proceed for domestic violence cases, essentially, and not push the reform for those cases.
I think that makes sense, Mr. Chair, and we've debated this for weeks, and so I think at this point, I think it this is the concern that several people have. I'm just hoping at some point we can vote up or down today because we've been on the same bill for a while. But I'm content with this amendment.
All right, we'll go Delegate Grammer and then Delegate Embry.
Yeah, thank you. Yeah, I think we've done a lot here. I think I'm okay with anything that kind of tightens the process. If we wanted to say broadly that these statement of charges could be filed under oath, for example, I think in general that's fine. I looked through the spreadsheet that was given to us for what was it, Wacomico. And I think it pretty clearly illustrates the reason why we should not limit the crimes to which this would apply, or even for warrant situations. Like, I think there's a lot we could do here that we could all agree on unanimously, that we don't need to, for what, in whatever capacity, limit the current process, whether it be charges or warrants or anything. I'm not for limiting it. I've dealt with situations where I've had constituents that have had to use this, and I don't think we should be limiting the way that they could have their situation heard to a commissioner whatsoever. So I'm for things if we want to tighten the process, restitution and additional penalties. I just think we should leave the changing the it's such a huge change to change this statewide for citizens. I don't think we should dabble into that this year.
And sorry, Chris, can you scroll down a bit? I want to see if they kept the expungement bit, the shielding language in there or not. Maybe not.
Yes, they did. They did.
They did.
All the way at
Okay.
the bottom. All the way.
Okay.
It's at the bottom, right?
Yes.
All right. Thank you. All right. So let's go to Cardin and then Embry, and then I will ask a question of the proponents of the bill.
So I just wanted to ask David, maybe you'll know the answer to this, but this is language that the State's Attorneys Association said they can live with, or do they like it?
So look, this is being presented as what everyone would like to see go forward to get this thing moving. The chair has asked me to be careful and deliberate about whether we can implement this. But before I even get to those questions, I just want to make sure people are comfortable with this direction. If people aren't comfortable with this direction, then there's no point discussing whether it can be implemented.
So if people are like Delegate Kaufman's giving his opinion, my opinion, I can do this. My opinion is that I think that I tend to prefer the clean bill, as it was originally presented by this or approved by the attorneys, but I am not. This doesn't do any violence to my conscience.
All right, Delegate Embry and then Delegate Eric.
Well, first of all, thank you. And I want to thank the sponsor, Delegate Addison, for all her work on this. I am comfortable with the bill as amended. I think it makes sense, at least as a first step. And I want to thank Patrick for sending data. I thought that was really interesting, especially the breakout within the domestic violence, that it includes all kinds of relationships. So I think I would love if, we could get statewide data, and then next year maybe we could revisit, learn from what we've done and maybe revisit. But I am comfortable with the bill as amended. Thank you.
Delegate Eric.
Yeah, I don't fully understand exactly. If you could scroll back up again, if there's so the substantive part of the bill that we sort of held for this week, essentially now they'll only be able to file this commissioner route if they are a person eligible for relief, aka they already have a protective order in place.
Eligible for.
Or they would be eligible for a protective order, so those are the only people that can go. I see Brian Levy shaking his head. Maybe he can answer.
Yeah, go ahead.
Thank you. A person eligible for relief under Family Law 4501 would be, and this list is not complete, but a formal spouse, a cohabitant, a person related by blood or marriage, a person who has a child in common, an individual who has had a sexual relationship with a person within the last year. This is a huge carve out that you're creating that, in our view, would essentially destroy this bill. This is the situations we see where the commissioner warrant system is being most abused. And let me give a specific example of what we see time and time again. A woman calls the police because she is hit by her boyfriend. The police come out. They arrest the boyfriend. the boyfriend gets released on bail and then goes down to the commissioner and files charges against his girlfriend. The girlfriend then gets locked up on a warrant and then comes to court, and the case resolves by way of both individuals invoking their Fifth Amendment rights. Abusers are using this system as a technique of coercive control against their victims. We have lots of protections in the law for victims of domestic and intimate partner violence. We allow police to make warrantless arrests for crimes not committed in their presence. We allow interim protective orders where a person can go 24 hours a day to a district court commissioner. Any victim of violence can go when a summons has been issued to the state's attorney.
Can I just pause you for a second there in the interest of time, though? Is it not true, though, that if we were to pursue the bill with the amendments, that problem would only exist for a fraction of the current population that is facing that? Would you agree with that? That the bill wouldn't be doing harm to your position in that perspective, right?
It would be a very large fraction.
Okay, let me ask a quick follow-up. You guys submitted an email suggesting you did not like the shielding language in the amendment. Are you sure about that?
I understand the very careful balance at play here. The truth is our clients typically learn and stay updated about their cases by their ability to go on case search and look them up. If you remove someone's ability to look up their case on case search, they're going to miss their court dates. And when they miss their court dates, they're going to have bench warrants issued for their arrest. It is also going to make it harder for them to apply for expungement of their court dates because the information they need to fill out a petition for expungement is on case search. So I understand you're here trying to protect the innocent defendants, but it's going to result in innocent defendants being locked up because they're unaware of court dates because they can't look them up online.
Can I just ask a follow-up, Mr. Chair?
Yeah.
Are the domestic violence people here, have they weighed in on the edited version?
From what I understand from the MSAA, that this was agreed upon language. Hassan, do you want to clarify that?
Yeah. So real quick, Delegate, this was the consent. This was not. We want a clean bill. We agree with OPD, but this was the consensus with Lisa Jordan in the domestic violence for us to come to a common sense solution to try to get it through the subcommittee and the committee.
Okay. All right. Thanks.
Okay. All right. So we can sort of sum the votes on the different options in a second, but let's just quickly get to this question that the chair has asked us to look at of feasibility. So since everybody seems comfortable with this, or not everybody seems comfortable, the people who are signing off on this are proposing this language. Does this require the commissioners to have some level of analysis, and are we comfortable that they're able to do that analysis to flag the cases correctly, that this is a person eligible for relief? Or are we clear that this then immediately translates, say, into a form, where if the person's one of X types of people, then they're eligible or they're not? Can someone give some insight as to exactly how we would implement the commissioner checking the person eligible for relief? And do we do this anywhere else? This was sort of the chair's question about whether we're making the commissioners make a determination. All right, Patrick Gilbert.
Thank you, Chair Moon. I think to an extent, commissioners already engage in these types of questions of complainants when they come into the commissioner's office. You'll see, as you look at sort of one of these types of complaints, you'll oftentimes see at the very bottom, sort of in a new paragraph, the complainant will write like, I know the defendant because we have a child in common. And that's a function of the commissioner saying, oh, I've read your statement. You need to include how you know the defendant. So to an extent, commissioners are currently engaging in this type of questioning. I think it would be relatively easy to distill the eligibility of a commissioner to issue a warrant into a type of form that could be provided to a complainant prior to filling out an application for statement of charges. that says like, is the defendant or the accused, someone who you are a cohabitant with, someone who you have a child in common with, and sort of you check those boxes and go down. So it will require the commissioner to engage in a degree of fact finding, but I don't think it's any significant extension over what the commissioner is capable of doing or already doing right now.
And sorry, do we need to say anything with respect to training and forms and things of that nature? Or is it assumed that these things come with just the type of change on text that we have before us?
That's a good question. I think additional training for commissioners would be really helpful for a number of reasons. So, commissioners don't have to be lawyers. They don't have to have gone to law school or to have passed the bar. And so I think that any additional training that would be provided to district court commissioners would inure to the benefit of everyone. I'm not sure it necessarily needs to be, put into this bill. But I think there's ways, I think certainly training for commissioners is a great idea.
All right, let's quickly hear from the House of Ruth. Dina Hausner's got hand up, sorry.
Thank you, Chair Moon. To answer the most recent question, it's my understanding that commissioners already do make that determination when they issue interim protective orders. They have to assess whether the petitioner is a person eligible for relief. So I believe it's already within their purview. And just to go back to a question earlier, the domestic violence advocates are very much in support of keeping the carve out for persons eligible for relief under the protective order statute as part of this. So we feel, I understand what Mr. Levy was saying, but we do feel that it's very important for victims of intimate partner violence to be able to apply for a statement of charges that results in a warrant. That's very important to their safety. So thank you. And I'm happy to answer any other questions relevant to the domestic violence.
Dawn Dalton.
Good afternoon. Thank you for giving me an opportunity to speak. As I testified on this bill for the last 2 years, my son being one of many who has had his life turned upside down by a jealous female utilizing the system as a weapon. I can say that this young woman had my son charged 22 times. My son has been through jury trials, speedy trials, the whole 9 yards in Prince George's County, Montgomery County, and in DC. DC has a much more thorough process. And that's all we're simply asking. For anyone to say that this is not a regular occurrence of especially young women utilizing this process as a weapon within the system is false. I'm so sure anyone working within the system sees this on a heavy rotation, and there is absolutely nothing done to these individuals once they cause harm to people. Okay, so be very clear. The individuals who have false charges placed on them are actual victims. And one thing that does bother me is for people to constantly say victim, 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 like the person that's filed in a false charge is a victim. They're not a victim, they're a criminal, and they need to be handled as such. And I just think it's really, really sad, to be totally honest, because in so many hearings, I hear it's actually like the victims are not treated as victims. And, there has to be a more thorough way to do this. Again, the young lady that did what she did to my son will go to the commissioner's office and make all types of charges of abuse and everything else with not a bruise on her. She got the warrant.
Thank you. I appreciate it. And again, we are trying to find if there's a way forward to at least start narrowing and help some people.
I understand that.
Duly noted. Well, colleagues, I think we're still in a little bit of a tight spot here.
Question, Mr. Chair.
Yes.
Just want to understand the bill with this proposed amendment largely keeps the current process for placing charges through a commissioner largely and broadly. That's still in place in the suggested amended version.
That is true. It's just for some people, and we start to ask other people to go to the police if they have an issue. which, you
Which
know,
people? I want to understand that clearly, because the only things that it seems to limit are the warrants. Am I wrong there?
correct. That's
Okay,
correct.
So
So you
any
can still bring a
charge.
charge. You can still have a charge. You know, I want to make that clear. We're not killing the process. This is just stopping a warrant from being issued on Friday and having someone put in jail over the weekend.
Yeah. So the only thing this limits is the charges to that one kind of example we talked about.
Yes.
Okay, gotcha. Thank you.
So let's just assume, for hypothetical sake, that everybody buys that it's going to be easy for the commissioners to make a determination and flag the cases correctly, and that we can make that as simple as possible. OPD is throwing a little bit of wrench in here, objecting to the shielding component, which I thought was a consensus component here. So I do think we ought to just quickly throw hands in the air here, or do a straw poll on this aspect of it. Is anyone inclined by the OPD arguments to remove the shielding aspect of our amendment? Raise your
Yes.
hand if you think we should remove the shielding aspect. And sorry, Delegate Embry, are you a yes to removing?
No, I'm not a yes, a no.
Okay, so it might just be Eric Hand and Grammer on the remove.
Yeah, I mean, remember we had that other bill, Mr. Chair, a couple years ago where we did shielding and it had a negative impact on.
Yeah, we had
the
immigrant
same thing,
attorneys
yeah.
complaining about. I mean, this happens periodically where there are attorneys who use case search as a, you know, expungement attorneys. We're talking about this, so it's definitely been a discussion. But again, the testimony we heard from the victims of the commissioner process was that they felt embarrassed by the allegations sitting up online, you know, for everyone to see. So
Can I just add one more thing? I mean, I hear that and I understand that they would be embarrassed, but if their own defense lawyers are saying that the benefits outweigh the risks, I feel uncomfortable shielding things when I think it's worse for them if they miss their court date. I mean, then they're really screwed. So, you know, a little bit of embarrassment or missing your court date, I don't know. I think if the defense bar or OPD was concerned more about them missing their court date than them, you know, being a little embarrassed, I would go with them.
all right. Are folks ready to vote on this, or do we want to entertain a special order to next week?
I'd be interested to know if the State's Attorneys Association also would be okay with removing the shielding part because of their general.
I mean, most of the members don't seem interested in that, but I'm curious what MSAA makes of this argument about knowing when your court dates are. Does anyone from MSAA have a comment on this?
So, Delegate, I will say this was an amendment suggested by one of our state's attorneys, Aisha Braithwaite, First Georges County. This was not a part of the original bill, and it's something that we're not going to try to get hung up on. I know Patrick's on here as well. He definitely speaks for the entirety of the state's attorney's office. I'm only speaking for State's Attorney Ivan Bates's office, but that's how this came about, the shielding amendment.
Right, Mr. Chair, maybe it would make sense, and this may be good for the delegate sponsor, for Delegate Addison, that we remove the shielding, and maybe it's consideration for next year if we find that shielding would be beneficial to these folks who are being who are up on case search and don't want to be. But I don't think we should take that action and then find out, as Delegate Erickson said, that we're regretting it because people are actually getting, you know, into trouble and problems because they can't expunge their case, their situation after they found out that actually the whole thing was false.
Is this, you know, I have to remind myself on shielding law, does this eventually get automatically, well, does this automatically get removed anyway at any point?
When you say shielding, I like to avoid the term shielding because people mean different things by the word shielding. We have this shielding procedure that was enacted quite a while ago, and I don't think it's used very. What we're doing here at the end of the bill is just simply removing it from from the case database.
Do they come out automatically anyway at a later point in time? This is what I can't remember out of case search.
They do not.
Do they drop off? No, they don't drop off
So
automatically.
so if the is that the timing, I mean, if the proceedings are ongoing, then certainly you might be able to use case search to look up the date. But we could pull them out of case search after the conclusion of the proceedings if nothing went forward and it wouldn't impact the current court dates. Could we not?
You still might have a problem expunging the case though, because then people might not know their case number.
Okay. Perhaps we move the shielding elements. I mean, we can always pull it back in the Senate bill or in full committee and deal with it that way. Again, unless people are just ready to rip the cord and vote on all aspects of this bill today. Delegate Bartlett.
Well, I just was going to say that it says, so we're saying that it's not going to refer to any of these, but these are final decisions. So if we're worried about people missing a court date, that would be during the pending phase. That's what I didn't understand OPD's point about missing court dates, because these are final decisions. No, not final, but
I think they wouldn't go up on case search at all though until the final decision
are made.
They would go up if it went forward and come down if it didn't. But then during the proceedings, it wouldn't be up at all for people to check their dates and what have you.
We're here. Can we hear from OPD?
Yes.
Yeah, so I want to correct, under current law, a dismissal, a null process, going to be automatically expunged 3 years after the expungement. And when something is expunged, it is going to be removed off of case search as well, right? Again, we are opposed to this amendment, and I think that may be surprising because we understand it's trying to benefit innocent people. Of course, all innocent people don't want the fact that their charges are present to be viewed, but the balance being struck is the reality in 2025 is when you have a court case, you are checking online to see when your court date is, right? There's other information that's put on case search that you need. When you apply for expungement, you need more than just your case number. You need your tracking number. You need the name of the complainant. You need the date that the warrant was served. Without being access to case search, it's going to create innumerable difficulties. And one of the biggest one of those, again, is people are going to miss court. You might get a summons for your first court date, but then it gets administratively postponed because it snowed, or because the state asked for it, or for other reasons. And the truth is, without case search, those individuals are going to miss court. They're going to have bench warrants out. And so it's a careful balance. And unfortunately, I wanted to make sure I was not an isolated individual in this. I spoke with every single supervisor of a district court in Maryland. Everyone uniformly agreed this would be bad for our clients.
Well, Mr. Chair, but I still didn't get to what I was trying to get to, and that is, I think number one does one thing, and number two does something separately different. And that's where I'm reading this a little differently. I'm reading number one as saying that if it results in any of these three things, it's not supposed to be shown on case search. I'm not reading that a pending case cannot be shown on case search. That's not what I'm reading in this. And then number two, I'm reading that for certain situations, unless there's a conviction, it doesn't even go on case search. That's the way I read it. And that's why it's a little I guess that's what I don't understand, Mr. Levy, is when you read number one, you're getting it as a pending case.
And Chris, can you scroll to that part of the bill?
He's there.
apologize, Delegate Bartlett. I'm not reading the law the same way you're reading it. The way I'm reading this is that a record of a case, the electronic record, would not be visible if it was until the final judgment, if it was issued by a non-police officer or state's attorney, meaning somebody with a pending open case that was filed by a civilian complaint would not be visible on case search.
That's an or though. So that's number 2.
Item 1 is current law. Item 1's current law.
Okay, thank you. Thank you. That was my problem, Claire. Thank you for reading my mind.
Bill sponsor has a comment.
Yes.
Oh, good afternoon, everyone. I really wanted the shielding, but if that's going to hold up the bill, I can live with it. But I really wanted to have the shielding because I know that you get notification in the mail prior to your court date. And so a responsible person will look at their notice and look at the tracking number, but I really wanted the shielding. But if this is going to move the bill on, I'll be satisfied with the shielding. But that was something that one of the state's attorneys recommended, and I thought we all agreed on the shielding.
Yeah, and at this point, honestly, with the shielding question, I think we'd have to kick it for another week if we actually want to include the shielding in there. I hate to say so.
Mr. Chair, can I make a motion to remove the shielding and move the bill as amended?
Second.
Okay, I guess. Okay. Claire, do you want to say something before we start rolling?
Yes, I have a question about another aspect of the bill, just to clarify this new language that has been added on the reprint on page 3 of 3. It's a new Roman numeral 6 underneath the underlined language in 5. And what the meaning of this is. The state's attorney's office shall have 72 hours from the receipt of the arrest warrant to make a determination of whether to move forward or release the defendant awaiting a court date or dismiss the charges. What does or release the defendant awaiting a court date mean?
So I think again, from the state's attorney's aspect and the adding on to Delegate Emery's wonderful amendment, which is right there in 5, typically we don't get the arrest warrants right away. Sometimes we don't get them for 14 days, if not more. Her amendment allows anytime that the warrant is served from a commissioner, it is automatically immediately sent to our office. And with the negotiations with the DV, that we now have 72 hours in our office, state's attorneys have okayed that we, within 72 hours, will review any warrant sent to us. If there is no evidence there to move forward with the case, that we will dismiss the case within that 72 hours. Now, again, you can, Ms. Claire, I'm not the bill writer. That's y'all job as counsel. So if you want to clean that up, we're fine with that. We were just trying to make sure that that was a part of the language of the bill.
Can we just strike or release the defendant awaiting a court date?
Yes, I think that was mistakenly put in there. Please do so.
Okay, so it just will say whether to move forward with the complaint or dismiss the charges.
Yes.
Great.
Okay.
All right, friends. So we're talking about the consensus amendments, no shielding, the addition of this language with the deletion Claire just referenced here. And we will retain the domestic violence exclusion from the law. We have a motion and a second. Is there any further discussion before we vote this amendment? All right. All in favor of this amendment, raise your hand or say aye.
Aye.
Does anyone want to be recorded in the negative? Okay, do I have a motion on the bill?
A move
Move
favorable,
favorable.
Mr. Chair.
Second.
All right, all in favor, raise your hand or say aye.
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 I want to explain my vote.
Hold on, is there anyone who wants to be recorded in the negative? All right, no. All right, but it sounds like you want to say something negative. Go ahead, Delegate Cardin.
I would have preferred to have voted the bill clean. I like the work that Delegate Addison did originally. I thought it was the right thing to do, but I am happy to do this consensus baby step. So.
All right, duly noted. Delegate Boucher, did you want to say something?
Yes, thank you very much. I want to thank Delegate Addison as well. This is something that is very personal to me. Also, I'm very grateful that the perjury language is in there, and a lot of responsibility is going to fall on the state's attorney's office to utilize that. I wanted the bill clean as well, but with the family law, that perjury line is so vitally important as a tool for the state's attorney to stop the abuse. It falls upon their shoulders. I dealt with a state's attorney that was totally negligent on this. They knew someone was filing false criminal charges and they did nothing about it. The duty falls upon the state's attorney's office to stop this abuse from taking place, and I hope they do so. So thank you very much.
Okay. This was a very fun exercise running through this bill, twists and turns at every subcommittee meeting, but hopefully we did the right thing today, and I guess on to the committee with this one. And we will be on to mail theft and porch piracy the next time we meet. So stay tuned, friends. That's it. You can have your Friday back.